Hey everybody, it's Yoli Medina, and I'm doing a follow-up to my last video that was regarding the hearing on the motion by the defense to be able to present evidence as to an alternate perpetrator or perpetrators. And there was a large portion in the court's minutes because this was a sealed hearing. And the court's order was to unseal the court's minutes with redactions. And I just want to show you the court's order so you understand what I'm talking about. And if you haven't seen my last video, I'll post it in the description box so you can look at it before you look at this one. So I'm going to share the screen. And this is the order unsealing and redacting records. So as I had mentioned in the previous video, there was a document, and for purposes of the court, it's document 12, which is here. 6/18/25, court minutes for the closed session re-motion concerning alternate perpetrators. So it says, although there is no longer a justification under ICAR 32I3A to warrant the continued sealing of the entire document, there were discussions recorded within the minutes that require protection. First, the minutes at 131:52 referred to identifying information of the proffered alternate perpetrators, the revealing of which would contravene the privacy concerns of these individuals and likely subject them to undue harassment. And I understand that. I totally understand that. And then it says, thus, this reference will be redacted pursuant to ICAR 32I 3A1 and 7. Then it says, second, the minutes starting at 136:17 through 27:05 document discussions regarding the status of an ongoing investigation into a potential leak in this case. This information is exempt from disclosure under ICAR 32G L or I and IC section 74-124A and therefore shall be redacted. So I in my last video I don't consider that portion redacted. I mean, it was a half an hour, and it was basically Ms. Barlow, who is the DNA attorney. I call her the DNA attorney because that's why she was brought in to address the IgG and the DNA match that was obtained by the FBI with the cheek swab that was taken in Pennsylvania. So, in my opinion, I said that it is not a redaction, it's sealed. And I still believe that. But what I wanted to point out is that's the problem with sealed hearings, is that other things go on in the hearings. I mean, this was a motion this was a defense motion for an alternate perpetrator to present evidence of alternate perpetrator or perpetrators. But yet other things were talked about in this sealed hearing. And I feel like it just gets very confusing for people who are following this case, and it causes a lot of speculation on the behalf of the public. And it's not clear, because if there was going to be a discussion about the status of the investigation into the leak, then that should have been separated as a separate hearing. So it could be sealed entirely, but it's a separate hearing and the public knows exactly what's happening. But other things were also discussed in this sealed hearing for the motion for the alternate perpetrator evidence, and it involved a potential juror who was a reporter and striking that juror, and everybody agreed. And it's just, it makes it so messy. And I'm surprised that the media isn't on this already, because the media has a right to follow this, and people have a right to follow this case. And there should be demarcations on when the motion for the alternate perpetrator, when that hearing ends and when something else begins. And here it's just all bundled up, and it causes me to question it, because Bika Barlow, she's never really spoken unless it's on the DNA issue. So why would she be having a over a half an hour conversation with a judge about the status of the leak. I would think that Ann Taylor would be the one talking about the leak, the status of the investigation of the leak. And this is that whole entire portion that is sealed is Bicca Barlow and the judge. And then at the end, the state chimes in, but we don't know what they say. So this is the problem that I've had with this case. It is so difficult to follow. And I'm just bringing this up because it shouldn't be this way. A case should not be difficult to follow. And I get it. Idaho has statutes that allow for sealed documents, sealed hearings. I get it. But it needs to be really demarcated as to when something is sealed and when another hearing is had that is sealed. Because when it's all jumbled up like this, you get information. And just the other day, one of the family members was on Nancy Grace, and they talked about how the judge told them that they needed to stop talking about the case, otherwise there wouldn't be a trial, and something to that effect. But that shocked me. Like, when did that happen? And I think it might have been in a hearing where the judge set a hearing for the role of the victims. As I recall, there was a section for the role of the victims. And I'm not sure, I mean, he set a hearing for that. Maybe that's where it occurred. But in any event, it was a sealed hearing. So these are the things that really bother me. And I guess, maybe Idaho's a little informal, but here in California, if I go for a motion, let's say a motion for summary judgment, and I try to bring up other things like, oh, well, the trial date is here and I want to continue, the judge will say, no, this is not before the court. You need to bring a motion for that. Or something to the effect that I will set a hearing for that. They'll tell you, I'll set a hearing for that. If you want to talk about that, we will talk about it. So that it's clearly demarcated. Otherwise, it's just, they can talk about anything. I mean, it's so informal. And this is such a high profile case, a Kohberger case, that I would think they would want to make sure they have everything where people can follow it accurately. Anyway, so this was like a hearing, a sealed hearing for the alternate perpetrator motion, and embedded in that hearing was a sealed hearing or discussion about the special investigation into the leak. And it's just, it doesn't seem right. It needs to be clearer for the public to understand what is happening in the case so that there isn't rampant speculation. Anyway, I'll leave it there, and I'll talk to you guys on the next one.